This morning, tensions rising at Donald Trump's hush money cover-up trial as the former president is held in criminal contempt for now the 10th time. Mr. Trump forced to pay another $1,000 fine soon, this time because he criticized the jury. While the judge gave the presumptive GOP nominee his sharpest warning yet, threatening jail time if Mr. Trump continues to break the gag order barring attacks on witnesses and jurors. Judge Juan Merchan saying he understood the magnitude of such a decision, adding, "The last thing I want to do is put you in jail. You are the former president of the United States and possibly the next president. But at the end of the day, I have a job to do."
Our Constitution is much more important than jail. It's not even close. I'll do that sacrifice any day.
This as the state pivots away from the more salacious evidence of the alleged effort to bury stories that could have damaged Mr. Trump's chances at the presidency.
Good evening, guys. Dr. John here. So let's get started. 10 criminal contempt findings from a single judge in one trial alone. And that's just the opening chapter. What's been assembled against Trump is the most extensively documented pattern of contempt ever recorded against a major American political figure, spanning multiple courts and culminating in 34 felony convictions. Judge Juan Merchan presided over the New York hush money trial with the patience of a man who has seen
by paying women hush money, which he denies. Now to the more granular details of the charges he actually faces for allegedly doctoring his internal books to cover up how he reimbursed Michael Cohen, his former fixer who paid off a porn star days before the 2016 election.
Mr. Trump, is Michael Cohen a liar?
I have a gag order. I'm not allowed to answer that question. This has never happened in this country before.
Two longtime Trump Organization employees on the stand Monday, walking the jury through Cohen's invoices. Checks Mr. Trump signed repaying Cohen in monthly installments, and internal ledger entries for, quote, legal expenses, all created under a phony retainer agreement prosecutors say was done to cover up the true reason for the repayments. While on cross-examination, Mr. Trump's defense team sought to emphasize neither witness can directly tie Mr. Trump to how the repayments were recorded.
everything the criminal justice system can throw at a courtroom and thought he was prepared. He was not prepared for Donald Trump. Before the trial even began in earnest, Merchan recognized that standard procedures were not going to be sufficient. He issued carefully crafted gag orders that prohibited public statements targeting witnesses, jurors, court personnel, and the family members of court personnel. These were not broad, speech-chilling edicts designed to silence political debate.
So we've had trial for a few weeks now. What is the rest of the case likely going to look like as far as the prosecution's case in chief?
The challenge for prosecutors is there is no smoking gun. There is no email. There is no tape that can actually prove the former president's intent. And so unless he gets on the stand and is cross-examined and something explosive happens, they really don't have a way to actually prove that part of the case. They've done a lot to show his motivation and this alleged conspiracy, but they haven't actually gotten into the falsification of the records and
Intent to falsify?
Yes, intent to conceal it.
Okay,
exactly.
Okay.
Either one of those, and they haven't really done that yet. Now, they say they have about roughly 2 weeks left here.
Okay, Laura, we shall see. Thank you.
They were surgical instruments aimed at preventing exactly the kind of witness intimidation and jury contamination that can destroy a criminal proceeding from the inside. And Donald Trump, sitting in the defendant's chair with the eyes of the world upon him, made a conscious choice. He chose to violate those orders. He chose to attack Michael Cohen by name.
Welcome into CBS News 24/7. I'm Muko Odigwe. We have breaking news from the federal judge overseeing the case involving deportation flights to El Salvador. U.S. District Judge James Boasberg says he found probable cause to hold the Trump administration in criminal contempt. The judge says it's for violating his orders to turn around those planes that were carrying migrants to El Salvador. So let's bring in CBS News Department of Justice reporter Jake Rosen for much more on this. Jake, what can you tell us? What have you learned?
Well, in Judge Boasberg's scathing 40-plus page memo, he writes, "The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it." The order at the center of this came on March 15th when Judge James Boasberg, after blocking the deportation temporarily of 5 men, expanded that block of people who the Trump administration was attempting to deport under the Alien Enemies Act.
He chose to attack Stormy Daniels by name. He chose to go after court staff. He chose to drag Merchan's own family family into the public square and subject them to the kind of scrutiny and threat that no family member of a public servant should ever have to endure. Each time he did it, Merchan made a factual finding. Each time, the contempt determination was specific, documented, and undeniable. By the time the gavel fell on the trial, there were 10 of them.
To over 200 people on 2 different flights that were on their way to El Salvador, he ordered those planes that were on their way down there so that prisoners could be put to that Supermax prison, the footage of which from that day you're seeing on your screen right now. The planes did not stop, and they were outside of U.S. airspace at the time, the Department of Justice argues, and thus the judge had no authority to order those planes turned around. As a result of this, the judge and the government's lack of explanation over multiple court hearings of why they didn't listen to the order and who, Mugo, specifically at the White House or Trump administration, ordered those planes to continue despite his order. Really, we're at a break point in terms of the federal engagement between the federal judiciary here and the White House. The White House now has to be held accountable, Boasberg says, for not turning these 2 planes around. He's ordering contempt proceedings to officially begin, saying he wants to find out, either the government can admit to who at the White House.
10 separate moments where a judge looked at the evidence and concluded that Donald Trump had willfully defied a lawful court order. The fines totaled $10,000, a sum so trivial to a man of Trump's wealth that it barely registered as a rounding error. But the warning that accompanied those fines was anything but trivial. Merchan stood on the bench, looked at a former president of the United States, who was now a convicted felon, and told him in open court that if the violations continued, the next step would not be a monetary penalty.
Didn't turn those planes around, or he will get to the bottom of it through potentially live testimony on the stand or further ordered depositions in this case.
Jake, I have to ask you, though, what could be the consequences here?
Well, if the Department of Justice, I should back up, the Department of Justice has to agree potentially to even hear this case and prosecute themselves, essentially, in terms of this criminal conduct. If they don't agree to do that, Judge Boasberg argues that he has the power to appoint someone who will prosecute the Department of Justice for not listening to his order. Who that is obviously remains to be seen. We'll see how the Department of Justice and the Trump administration react to this, but any enforcement mechanism, whether it's a fine, whether it's potentially sanctions on someone of some kind, would have to be enforced by the U.S. Marshal Service and the Department of Justice. But Judge James Boasberg, despite the Supreme Court ruling that his temporary restraining order blocking these deportations, that order was struck down, but he says the contempt proceedings that were started in that case before the Supreme Court's order are going to continue, and he's going to get to the bottom of this.
The next step would be jail. A sitting judge in New York State warned a former and potentially future president that his continued contempt of court could land him in a cell. That warning echoed through the marble hallways of American jurisprudence like a thunderclap, and it established a precedent that no amount of political spin can erase. Now, if the Merchan contempt findings were the only chapter in this saga, they would already represent an unprecedented moment in American political history.
And he really cited the boasts by the Trump administration after those planes landed, saying that they wouldn't turn that around, and all of the things cited in court by the Trump administration, basically saying, Judge Boasberg, you don't have the authority to even ask questions about this because this is a national security issue and we're dealing with foreign governments. You're entitled to no information. Boasberg said that's not true. He's going to get to the bottom of this situation.
Wow. Much more to come out of this one, I'm sure. Jake Rosen, thank you so much. We'll talk to you again, by the way, in just a few minutes. For more on how the White House is responding to all of this, let's bring in CBS News senior White House correspondent Weijia Zhang. Weijia, any reaction from the president on his administration possibly being held in contempt of court right now?
We have not heard directly from President Trump, and we have not even heard directly from the White House about their reaction to this ruling, even though we have asked. So it could come up at any time, but so far.
But the story does not end in that Manhattan courtroom. It spreads outward into the federal judiciary, where judges appointed by presidents of both parties have found themselves confronting an administration that seems to view court orders as suggestions rather than commands. Federal Judge James Boasberg stepped into this vortex when he examined the administration's deportation flights to El Salvador.
They, are remaining silent about this, but it is very possible that the president could weigh in. He has been adamant that his administration did nothing wrong because he did use a wartime law to basically say that he's able to do this because he claims that the U.S. is at war with Venezuela, and that's why they had to deport these criminal migrants. War, not in the literal sense of a traditional war, but the war on illegal immigration and drugs and violence. And so they, in the past, have been extremely bullish on this in saying that they haven't done anything wrong, and saying that the judge, as Jake laid out, does not have this jurisdiction to order the government to do things when they are literally in the air.
The administration had invoked the Alien Enemies Act, a statute that dates back to the earliest days of the American Republic, to justify rapid deportations to the notorious CECOT prison facility. Multiple courts examined that legal justification and found it wanting. The statutory language did not support what the administration was doing. The courts issued orders. They told the administration to turn the planes around.
And we know one of the people on those flights was Kilmar Abrego Garcia. A hearing on his case was held just yesterday. And today, Democratic Senator Chris Van Hollen arrived in El Salvador with one goal. Let's listen to what he had to say. We'll talk to you on the other side.
As I've said before, the goal of my visit is to talk to people here about the release of Kilmar Abrego Garcia. I told his wife and his family I would do everything possible to bring him home. And we're going to keep working at this until we're successful. I also hope to have the chance to meet with him, but we'll have a better idea if that works out a little later on.
So, Weijia, what is the next step here? We know the judge is giving both sides until next week for depositions.
Well, the senator says he wants to talk to people about Abrego Garcia's possible release, but the person he would have to talk to is the president of El Salvador, who was just here at the White House this week and made it very explicitly clear that he has no intention of releasing him back to the U.S. In fact, he used the word smuggling a terrorist back to the United States. And so the senator can go there. He might be able to get onto the grounds of the prison. We don't know that yet. And we certainly don't know if he'll have any FaceTime with this man. But he, I think, is trying to make a statement that somebody in this country, wants him to come back to the United States, because this administration has said many times over that they have no intention of asking for him back.
And the administration, faced with a clear judicial command, made a choice. The flights continued. The planes landed. The deportees were delivered into conditions that human rights organizations have spent years documenting as severe and deeply troubling. Boasberg looked at this sequence of events and reached a conclusion that should shake every American who believes in the constitutional separation of powers. He found probable cause for criminal contempt. He determined that the defiance was willful, that it was not a misunderstanding, not a bureaucratic error, not an unfortunate miscommunication between agencies. It was a deliberate decision to ignore a federal court order and proceed with a policy that the judiciary had specifically halted. That finding is now part of the permanent record, a foundation stone upon which future proceedings may be built. The CECOT dimension of this story deserves its own moment of scrutiny because it reveals the human consequences of decisions made in Washington conference rooms. The Terrorism Confinement Center in El Salvador is not a standard immigration detention facility. It is a prison complex designed for maximum security, and the conditions inside have drawn sustained criticism from international human rights monitors. People sent there face circumstances that previous American administrations, both Republican and Democratic, have specifically sought to avoid. The Trump administration's decision to send deportees to CECOT was not merely a policy disagreement with the courts. It was a substantive choice with real human stakes, and the courts had ordered that those stakes be paused while the legal authority for the deportations was properly litigated. The administration's refusal to pause, its insistence on pushing forward despite judicial orders to the contrary, is the conduct that Boasberg's contempt finding addresses. This is not about immigration policy preferences. This is about whether the executive branch must obey the judicial branch when the judicial branch says stop. The pattern extends further still into the machinery of federal law enforcement appointments. Federal Judge Cameron Curry examined the appointment of Lindsay Halligan as the United States Attorney for the Eastern District of Virginia and found something that should alarm anyone who cares about the integrity of federal prosecutions. The administration had used interim appointment procedures that circumvented the vacancy laws Congress enacted specifically to prevent this kind of maneuver. The appointment was not just procedurally sloppy, it was illegal. Curry ruled accordingly, and the practical consequences were immediate and severe. Cases that Halligan had been handling, including matters involving Comey and James, were tossed. The legal work product of an improperly appointed prosecutor was deemed invalid. And this was not an isolated incident. 7 different states have faced challenges to U.S. attorney appointments, suggesting a systematic approach to staffing federal prosecutorial offices that prioritize speed and loyalty over legal compliance. The cumulative effect of these rulings is a federal judiciary that is actively, case by case, order by order, pushing back against what multiple judges have identified as executive overreach. The judicial response to the administration's conduct has not been limited to contempt findings and appointment reversals. The Supreme Court itself has produced language that will be quoted in history books for generations. Justice Sonia Sotomayor's dissent in the immunity case contained a sentence that cut through the legalese and spoke directly to the American people. She wrote that the majority's ruling made the president a king above the law, and she concluded with the words, "With fear for our democracy, I dissent." That dissent has been quoted in campaign advertisements, in academic journals, in congressional hearings, and in living rooms across the country. Justice Ketanji Brown Jackson wrote separately about what she called a law-free zone, a space where presidential conduct exists beyond the reach of accountability. Justice Amy Coney Barrett, a Trump appointee, wrote a partial concurrence that specifically rejected the majority's evidence rules, signaling that even within the court's conservative wing, there was discomfort with the breadth of the immunity doctrine. And outside the court, prominent conservative legal scholars like Judge J. Michael Luttig have publicly criticized the ruling, adding intellectual heft to the concerns that Sotomayor and Jackson articulated. The cumulative judicial concern, expressed in opinions, dissents, and public statements by judges across the ideological spectrum, represents a qualitative shift in how the American legal establishment views the relationship between presidential power and legal accountability. The attacks on judges themselves form the most personally disturbing chapter of this entire narrative. Donald Trump has not merely disagreed with judicial rulings through the normal channels of appeal and legal argument. He has turned individual judges into targets. He has called them lunatics. He has labeled them radical left operatives. He has described them as corrupt enemies of the people. These are not the words of someone engaged in good faith legal debate. These are the words of someone trying to delegitimize the institutions that hold him accountable. And the attacks have produced consequences that are neither abstract nor theoretical. After Trump attacked Judge Arthur Engoron following the $464 million civil fraud judgment, Engoron received specific, documented security threats. His family was threatened. Protective measures had to be implemented. The same pattern has repeated with Judge Merchan, whose daughter became a specific target of Trump's public statements and the online mob that follows his cues. Judge Tanya Chutkan, who presided over the federal election interference case, has faced threats. Judge Eileen Cannon, who actually ruled in Trump's favor on key motions in the classified documents case, has not been spared from his attacks when her rulings did not go far enough or fast enough to satisfy him. The message to every federal judge in America is unmistakable. If you handle a case involving Donald Trump, you will be attacked. Your family may be attacked. Your security will be at risk. And the attack will come regardless of how you rule, because the standard is not legal correctness. The standard is total loyalty. The security implications of this sustained assault on judicial independence are both immediate and long-lasting. Federal courts have had to implement enhanced security measures that were previously unthinkable. Judges who once moved freely through their communities now require protective details. Courthouses that were designed to be open and accessible to the public have become hardened facilities. The financial cost of these measures runs into the millions, but the institutional cost is far higher. Every dollar spent on judicial security is a dollar not spent on improving court access, speeding up dockets, or modernizing outdated systems. Every judge who retires early because they do not want their families subjected to this kind of pressure is a judge whose experience and wisdom is lost to the system. Every qualified attorney who declines a judicial nomination becomes because they have seen what happens to judges who cross Trump is a talent that the federal bench will never benefit from. The structural damage to judicial independence is not something that can be repaired with a single election or a change in administration. It is a corrosion that seeps into the foundation and weakens the entire edifice over time. The defenders of Trump have their arguments, and those arguments deserve to be aired because fair analysis requires engaging with the strongest version of the opposing case. They will tell you that the contempt findings in New York were the product of a partisan judge pursuing a political agenda. They will argue that strong criticism of judicial decisions is protected by the First Amendment, and that politicians have always pushed back against court rulings they disagree with. They will frame the deportation flight situation as a legitimate disagreement about the scope of executive authority rather than a willful defiance of judicial power. They will point out that judicial security concerns are sometimes exaggerated by media coverage that is itself hostile to Trump. They will insist that a former president facing multiple legal proceedings has every right to defend himself vigorously in the public arena. These are not frivolous arguments. The First Amendment does protect robust criticism of government officials, including judges. Political disagreements with judicial rulings are a normal part of democratic life. The line between vigorous defense and witness intimidation can sometimes be blurry, and reasonable people can disagree about where that line falls in specific cases. But the defense collapses under the cumulative weight of the evidence. The 10 Merchan contempt findings were not based on a single disputed statement or a close call about where the boundary of the gag order lay. Each finding was a specific factual determination that Trump had violated a specific court order that his own lawyers had the opportunity to challenge and shape. The Boasberg probable cause finding was not about a policy disagreement. It was about the administration ignoring an explicit court order to turn planes around and proceeding with deportations that multiple courts had found legally questionable. The Halligan ruling was not about partisan bias. It was about an appointment process that circumvented federal vacancy laws. The pattern of security threats against judges has been documented not just by media reports, but by the security measures that courts themselves have implemented. The defense requires believing that multiple judges across multiple jurisdictions, appointed by presidents of both parties, handling different cases involving different legal issues, all somehow coordinated to produce findings against Trump for reasons other than the conduct those findings describe. That is not a legal argument. It is a conspiracy theory, and it cannot survive contact with the documentary record. The implications of this cumulative record for the future of American governance are profound and unsettling. A constitutional system depends on the willingness of the governed to accept the authority of institutions, even when those institutions produce outcomes they dislike. When the executive branch demonstrates through repeated actions that it views court orders as advisory, it erodes that willingness. When a former president normalizes the practice of attacking individual judges as corrupt enemies, it teaches his supporters that the judiciary is not a co-equal branch of government, but a hostile force to be delegitimized and defied. The Boasberg contempt finding is particularly significant because it addresses conduct by administration officials acting in their official capacities, not the personal statements of a criminal defendant. It suggests that the defiance of judicial authority is not merely a rhetorical posture, but an operational principle. The Halligan ruling and the broader pattern of challenges to U.S. attorney appointments suggest that the administration has been willing to cut legal corners in staffing the very offices responsible for federal law enforcement. Taken together, these patterns describe an executive branch that has internalized the message that legal constraints are obstacles to be circumvented rather than boundaries to be respected. The Sotomayor warning haunts this entire analysis. When a sitting Supreme Court justice writes that the court's ruling has made the president a king above the law, she is not engaging in hyperbole. She is describing the logical endpoint of the trajectory that the contempt findings and judicial pushback reveal. A president who can defy court orders without consequence, who can attack judges without restraint, who can install improperly appointed prosecutors to pursue his agenda, who can claim immunity for conduct that that would land any other citizen in prison is a president who operates beyond the reach of the legal system. That is what Sotomayor meant by a king above the law. That is what Jackson meant by a law-free zone. That is what Ludwig and other conservative scholars meant when they criticized the immunity ruling. The concern transcends partisan affiliation because the structural problem would exist regardless of which party held the White House. The question is whether the American constitutional system contains sufficient resilience to reassert the principle that no person, not even a president, is beyond the reach of law. The short-term beneficiaries of the judicial pushback are the institutions themselves. Every contempt finding, every ruling striking down an illegal appointment, every probable cause determination for criminal contempt strengthens the documentary record that future courts, future Congresses, and future historians will rely upon. These rulings create a paper trail that cannot be erased by a press release or a social media post. They establish precedents that constrain future administrations regardless of party. They demonstrate that the judiciary, whatever its flaws and whatever the legitimate criticisms of individual judges, retains the capacity to function as a check on executive power. The career judges who issue these rulings, many of whom will serve for decades after the current political moment has passed, benefit from the clarity that these decisions provide. Future defendants benefit from the precedent that political power does not exempt anyone from the obligation to comply with court orders. Independent media organizations benefit from the substantial documentary evidence that allows them to report on these issues with specificity rather than speculation. The losers are equally clear. Trump himself faces an unprecedented multi-front legal pressure that no amount of political rhetoric can fully deflect. The contempt findings will follow him into every future legal proceeding as evidence of a pattern. The Boasberg finding may yet be converted into formal contempt charges with consequences that extend beyond the reputational. The administration loses the ability to operate without judicial scrutiny, a constraint that limits its policy flexibility and forces it to defend its actions in forums where evidence matters. The judges who have ruled against Trump face continuing security risks and personal pressure, a burden that no public servant should have to bear, but that many now carry as the price of doing their jobs. The American judicial security infrastructure faces continuing strain that will require sustained investment and attention long after the current cases are resolved. What comes next will depend on decisions that have not yet been made. One scenario involves the continued accumulation of contempt findings and adverse rulings as additional cases work their way through the federal courts. Another involves the conversion of the Boasberg probable cause finding into formal contempt charges that could trigger a new phase of legal jeopardy for administration officials. Additional federal judges may find themselves targeted by public attacks if they handle politically sensitive cases. The cumulative judicial response could become a significant factor in future elections by providing voters with documented evidence of administration conduct that they can evaluate at the ballot box. The 34 felony convictions from the New York trial are already a matter of public record. The 10 contempt findings from Merchan are already documented. The Boasberg finding is already part of the federal docket. The Halligan ruling has already invalidated prosecutions. None of this can be wished away or memory hold. It exists, it is real, and it will continue to shape American politics, whether or not the mainstream media chooses to give it the sustained attention it deserves. The core question that this entire saga forces upon the American people is deceptively simple. Do we want a judicial system where contempt findings actually mean something, where court orders carry the force of law regardless of the power or position of the person they are directed toward? Or do we want a system where political power creates a de facto exemption from the rules that everyone else must follow? Do we want judges who can enforce their orders even when those orders constrain a sitting president? Or do we want an executive branch that treats the judiciary as an advisory body whose recommendations can be accepted or ignored based on convenience? Do we want judicial security to be treated as a priority that transcends partisan politics? Or do we want a world where attacking judges and their families becomes a standard political tactic that chills judicial independence and drives qualified people away from the bench? These are not abstract philosophical questions. They are the concrete stakes of the contempt findings, the judicial rulings, and the documented patterns of attack that now form one of the most extensive records of judicial pushback against any political figure in American history. The evidence is not hidden, it is not disputed in its factual particulars by anyone who has actually read the court filings. Judge Juan Merchan's 10 contempt findings are in the record. The $10,000 in fines are in the record. The jail warnings are in the record. The specific violations involving Michael Cohen, Stormy Daniels, court personnel, and Merchan's family are all documented. The 34 felony count convictions that resulted from the underlying trial are a matter of public record. Judge James Boasberg's probable cause finding for criminal contempt, the deportation flights that continued despite court orders, the Alien Enemies Act invocation that multiple courts rejected, the arrival of deportees at CECOT despite judicial commands to turn the planes around, all of it is documented in federal filings. Judge Cameron Curry's ruling that Lindsay Halligan was illegally appointed, the vacated cases, the 7 state attorney appointment challenges, all of it is in the dockets. The attacks on Judge Engoron after the civil fraud judgment, on Judge Chutkan during the election interference case, on Judge Cannon during the classified documents case, the security threats, the protective details, the enhanced courthouse security measures, all of it has been reported and confirmed. The Sotomayor dissent, the Jackson dissent, the Barrett partial concurrence, the Luttig criticism, the cumulative judicial concern expressed through opinions and public statements, all of it is available for anyone willing to look. This is not a story about partisan interpretation. It is a story about documentation. The question now is what the American people and their representatives choose to do with the documentation that exists. The record is complete enough to support accountability. Whether accountability actually arrives is a question that no judge can answer alone and that no contempt finding can resolve by itself. That question will be answered by the political process, by the willingness of voters to demand that their leaders respect the rule of law, and by the resilience of the institutions that the contempt findings and judicial rulings are trying, against significant pressure, to protect.